Okay, so you've bonded out of jail and you got a bond condition that says that you cannot have any contact with your spouse. What are you supposed to do at this point? Hi, my name's Zeliff Watson, and this video is for current or new clients of mine to further discuss what we touched on in the initial consultation about bond conditions. So here's the deal. With bond conditions, judges have a lot of discretion under Georgia law in setting reasonable conditions of bond, as prohibitions oftentimes on what you can and can't do while you're out on bond. This could be a 30-minute video, so for purposes of today, we're going to keep it to no contact bonds. In a lot of counties, if you've bonded out on a family violence case, family violence battery, family violence simple battery, family violence assault, perhaps sometimes even things like a disorderly conduct case, but the family violence cases, you're going to have a no contact bond set into place. And a no contact bond is a no contact bond. All the judges would agree. That means you can't email, text, otherwise correspond, certainly can't live at the same residence or address, so on and so forth. And so this, of course, is a hardship for many reasons. So what we plan on doing and what we'll do in your case is discuss filing a bond motion to amend the bond. What will happen is we're entitled to a hearing if we elect to file that motion. We're entitled to a hearing that will be set by the court. Now, unfortunately, there's no particular timeline rules that are in play here. So the court hearing, you can't expect it to be within the next 72 hours or the next 24 hours or even a week or two down the road. But that's why it's important that we do this as expeditiously as possible to ensure that you have your day in court sooner than later about a restrictive bond condition. So if you've left my office and we discuss things, proactive steps perhaps that you can take that increase the likelihood of you getting the bond changed, then by all means, start those proactive steps. Leave it to my office to file my name on your case. Leave it to my office to file a motion to amend the bond. And I will be very specific in that motion as to what the current provisions are, what we're asking for, and why we're asking for it. And at the hearing, our goal at the bond amendment hearing or motion to amend bond hearing, our goal, of course, is to get the bond change so that you can absolutely return home with reasonable restrictions in place, like certainly no violent, harassing, or intimidating contact between you and the particular person covered. But again, leave it to our office. We will get that motion filed promptly, and we will certainly represent you in the battle to get your bond restrictions amended to allow you some normalcy back in your life. If you have further questions, certainly call my office.